Okay, Chapter 5, Part 12. Alright, so the evidence is presented by the parties. The plaintiff has now presented their case. At the end of the presentation of the plaintiff's case, the judge is going to usually turn to the lawyer for the plaintiff and say, call your next witness. The lawyer will then say, Your Honor, we have no more witnesses to call. The judge will say, do you rest? Yes, we rest. That is a key factor. Once the plaintiff rests, they cannot present any new evidence. There are always exceptions to everything, but that is the rule 99% of the time. So at that point, generally, the defense will make a motion for a directed verdict. What that means is that the defendant's going to say to the judge, Your Honor, in order to prove their case under the law, there are 5 elements of that case that they have to prove. They have not offered any evidence on element number 3. If the judge agrees with them, then the judge has to grant a directed verdict because the plaintiff has failed to prove their case. Okay. The defendant then presents their evidence. The same manner in which the plaintiff presented their evidence, the plaintiff can cross-examine those witnesses, and it goes back with recross and redirect, etc. Okay, we call that rebuttal, rejoinder, and surrebuttal. Okay, the next phase, after the defendant has presented their case, the plaintiff is entitled to rebuttal, and then the defendant surrebuttal. The close of the evidence occurs, and we're ready to proceed with closing arguments. But sometime before closing arguments, maybe right before, or it may have been significantly before, the judge is going to meet with the attorneys to have a discussion on the charges to the jury. Okay, these are the legal rules that the judge is going to tell the jury that they have to apply. So, for example, the judge might say, ladies and gentlemen of the jury, in order to have a valid contract, the plaintiff has to prove that there has been an offer and acceptance, which we call the agreement, consideration, capacity, and legality. And without those elements, there was no contract that could be enforced. Okay, where does the judge get the law from? Well, the judge gets the law, obviously, from the sources of law, the Constitution, the statutes, and the case law. But in the federal system and in Georgia, the court systems have adopted what are called pattern jury instructions. It's a notebook full of instructions on the most common areas of law, and they've been adopted and approved by the Supreme Courts, so that there's no question of the judge making an error in the form of the charge to the jury. Now, whether the judge should have actually given that charge or not, that could be error. Okay, so in most situations, the judge is going to pull out those pattern jury instructions and is going to use those. Now, on occasion, there may be something that's not covered by a pattern jury charge, in which case the parties may submit some. The judge makes the final decision on those and carves out the final instructions for the jury. When they go back in the courtroom, the judge is going to give the attorneys on the record a chance to object to the decision with regard to what to charge. That would be not in the presence of the jury, but on the record. That's for purposes of appeal, to preserve your objection to those charges. Okay, so then the lawyers are going to make their closing arguments to the jury. Now, who goes first in the closing argument is jurisdictional and the type of case dependent. And whoever goes first sometimes has the right to also go last, so they can reserve their time. So one party may go first, then the other party, then the original party gets a second shot at closing arguments. Now, the difference between a closing argument and an opening statement is that in a closing argument, the lawyer can argue from the facts. So if anything was presented as an alleged fact, even if it's not particularly believable, the lawyer is allowed to argue from that. You cannot object to that. So it's more leeway given in closing arguments. The lawyers at this point know what the jury charges are going to be. They have to know because they want to be able to argue those to the jury, to tell the jury the judge is going to charge you on this, and this is how it fits into the case. If the lawyer doesn't know that, they could make a mistake there, and that could be embarrassing to the, in front of the jury, as well as harmful to their client. Okay, so the judge's charges are not going to only be on the substantive law, but also on procedural issues and related substantive law, like standard of proof, etc. So there's going to be a lot of different charges. The judge usually reads those charges to the jury. Some judges will put them up on a screen while they read them. Some will actually give the charges in writing to the jury. Most judges simply read it to the jury, and that can be problematic. I practiced in front of one judge who mumbled through jury charges, and sometimes the jury charges went on for 20 or 30 minutes. It's amazing the jury picked up any of those charges. But the lawyers will remind the jury in their closing argument what those charges were. Okay, so we're going to finish there with part 11, and we'll pick up with part 12.